The draft terms of reference, made up of inputs from political parties, was read out to MPs. But one particular point stood out, and that was the wording around whether President Ramaphosa, who is at the center of this entire saga, should appear in person to testify.
And the information is peculiarly within the knowledge of the president. So he doesn't have a choice with respect, and I'm glad there seems to be consensus that evidence must be given by the president himself and not through an intermediary or a representative. Secondly, obviously, if the president chooses not to give evidence, the law will apply its course. The law cannot be redefined by us in this committee.
The wording as presently formulated that the president can elect to give evidence, and should he, firstly, the issue of through an intermediary, which we would not support according to our document. Secondly, the issue of whether he gives evidence at all, and should he not give evidence, whether an adverse inference can be drawn from that. And the present clause says no adverse inference can be drawn, and I think that is incorrect as a matter of law. A negative inference could possibly be drawn from a lack of giving evidence.
We don't believe that he should be able to give evidence in absentia. We also agree with the negative inference suggestion that has been made previously. We absolutely agree with that.
The question of the president coming to testify, it is one of the most paramount issues that need to be dealt with, because you can't have an inquiry over the president and the president does not come to testify, because him testifying, that is an integral part of the ideals and the purpose of the Section 89 process of holding him accountable. Therefore, you can't hold someone accountable without having that person coming to testify and answer to what is put before him.
It must be noted that the EFF objects to the president not giving evidence himself. Will be failing the people of South Africa. We'll be failing ourselves. We'll be failing in our duties to hold the executive to account. He's an individual who's been elected into an office, not through lawyers, by him, and him taking the oath of office. So he must come here. The same way he answers questions in Parliament, that's holding the president to account. He's now compelled, not even by Parliament, by the Constitutional Court, to come and be held accountable here.
But not everyone is in agreement with this.
We believe that the president cannot be compelled to testify. His participation is a right to be heard, not a duty to give evidence. And non-testimony should not have an adverse inference, because it can't be weighed against the president when we consider the duty and the right aspect that I've mentioned.
Committee Chairperson Makashule Ghana wants to seek legal advice on this.
I think for me it leaves a bit of a legal question that I would like to ask legal, if at all, if they can assist, whether we can compel the president to testify, and if he doesn't, what does that what will that mean for the committee? Because I think there's that issue around the negative inference that might have to be made in that regard, because so that we are on the right side of the law. I know that we might have our desires as members. We also don't want the rules themselves to be challenged if someone chooses not to testify and believe that there's no case to answer.
The committee will also write to the Noble panel asking them to appear to present their report. Meanwhile, MPs could not settle on the issue of who would lead evidence in the process. The names of 5 advocates are currently on the list, that being Kate Hofmeyer, Zinzile Matebese, Vuyani Ngalwana, Ishmael Jamie and Pule Seleka. But MPs agreed that this pool is not big enough and they have been given 48 hours to add names to it. They are meeting on Wednesday, the 29th, to conclude this matter. Abra Barbia, SABC News, Parliament.